If you're facing federal charges, one mistake by law enforcement could change everything. Did the police search your home, car, or electronic devices without a warrant or without consent? Did they question you without reading you your rights? If so, that evidence or your statements might be thrown out. I'm Diane C. I'm a federal criminal defense attorney, and in this video, I'm going to talk about how evidence and statements can be suppressed under the Fourth Amendment and Miranda. If you're being accused of a crime, you must know this information. First, let's talk about the Fourth Amendment and how it can be used to suppress evidence. The Fourth Amendment protects us from unreasonable searches and seizures. But what does that mean in real life? If law enforcement searches your home, your car, or your possessions without a warrant, the evidence that they obtain could be suppressed and kept out of court. However, there are exceptions to this rule. Here's a typical example. You get pulled over, the cop asks you if they can search your car, and you say no, but they search it anyway. If they didn't get a warrant, like seeing something in plain view or exigent circumstances like you were going to drive away or destroy the evidence, then that search is inadmissible. And guess what? That means that your lawyer can file a motion to suppress the evidence, and the prosecution can't use that evidence against you in their case. This is where the exclusionary rule and fruit of the poisonous tree come into play. So if any evidence is obtained as a result of the illegally obtained evidence, that evidence doesn't come in either. This can be the difference between a conviction and a dismissal. Now that we've discussed the Fourth Amendment, let's talk about the Miranda warning. I'm sure you've all heard the famous Miranda warning. You have a right to remain silent. Anything you say can or will be used against you. But here's the catch. Miranda only applies to what we call a custodial interrogation, which means that only if you're in a position where you are not free to leave, as in you are forced to sit on the curb and not get up, you are handcuffed, you are in the back of a police car, or you are in a police station involuntarily, that's when they have to read you your Miranda rights. If they're just talking to you and you start telling them stuff, they do not have to read you Miranda. If, however, you are in a custodial situation and they are asking you questions and they don't read you Miranda rights, then we can get those statements suppressed. So if you voluntarily talk to the police without being in a custodial situation, Miranda does not apply. So how do you protect yourself? Invoke your right to remain silent. Please say, I am invoking my right to remain silent. I would like an attorney, please. Now, a lot of people are in this situation. They feel like they have no choice and they have to talk. You don't have to talk to the police. You can be very polite, you can be cooperative, and just say, I'm going to invoke my right to remain silent. That's it. And the more they ask you questions, just stop talking, because they are experts at this. You are not. I promise you, this is the right thing to do. Ask for a lawyer immediately. Once you say, I want a lawyer, they have to stop questioning you. And trust me, they won't. They're going to keep trying. Just keep saying, I want a lawyer. I'm invoking my right to remain silent. I want a lawyer. Period. Never waive your rights without understanding the consequences. I have a case right now where my client was pulled over by an undercover cop who obviously knew that my client had drugs in the car, but they pulled him over allegedly because of a traffic violation. So instead of just writing him a ticket, they made him sit on the curb, they patted him down, and they asked for consent to search the car. And because my client did not know that he had a right to say no, they searched the car. He said yes, they searched the car and they found the drugs. If my client had invoked his Fourth Amendment right to say no, they would have had to have probable cause, they would have had to get a warrant. He would have been able to drive away with a traffic ticket. Instead, he has been charged with possession of a lot of cocaine. So understanding your Fourth Amendment rights and your Miranda rights can make all the difference in your case. If evidence was obtained illegally, or if you were questioned without being read your Miranda rights, this evidence could be suppressed. And that could weaken or even destroy the prosecution's case against you. Sometimes a person's statement or confession is the best evidence that the government has. I'm going to give a really strong example of that. I have a client right now who is charged with attempted murder for shooting somebody in the shoulder. And his statement where he said he wanted him dead is the worst evidence against him, because I could have argued that he didn't intend to kill him, he just intended to scare him or hurt him. But his statement sinks us. If you or someone you know are facing federal charges, don't wait. Contact my office immediately for a consultation. If you have any questions, comment below and I will do my best to answer. Thank you for watching, and I will see you in the following video.